This is for my students in PADM Public Administration 5322. We're in Module 4. We're in Chapter 4 of our textbook, and the topic regards the governance of hospitals and hospital systems by the board. The name by which the members of the board go depends upon the ownership of the hospital. If it's a for-profit corporation, then the members of the board are known as directors. If it is a government or nonprofit hospital, the members of the board are more likely to be called trustees rather than directors. The need for a board arises out of the separation of ownership from management. And it is the responsibility of the board to govern, not to manage, not to administer, but to govern. And if they, on occasion, get down too much into the details of the operations of the organization, that is not their appropriate role. They are a legally required body. They must exist, but they should be more than just a response to the legal requirement. They should actually govern, and they should actually have a relationship with the CEO and others who manage the hospital that is appropriate. They must not become a rubber stamp for the CEO or the chief of the medical staff or others. Even though, given the way things are done, it may appear that they are a rubber stamp. They should in fact be active participants in decision making, but not at the level of administration, but at the level of governance. In other words, when there is a formal meeting, the meeting may give the appearance that they are merely rubber stamping decisions that have been made by others. But they should, through committees and ad hoc committees, have been participants in those decisions, but only those decisions that qualify as being at the level of governance. And particularly, they are responsible legally for the quality of the medical services delivered, which means that they have the responsibility to be actively involved in the credentialing or in the acceptance of the credentials of the physicians who seek to have admitting privileges to the hospital. They should work at the level of mission. They should be involved in decisions involving acquisitions or mergers and so forth. This is governance. This is not management. They are required by law and by the Joint Commission on the Accreditation of Hospitals to prepare and maintain their own bylaws. By the way, I'm working from speaking notes that are available to you on our website. They are required to oversee administration and clinical services of the hospital, but only to oversee, not to get involved in the details. They are responsible for the quality of the medical care provided. You can refer to page 115 of our textbook. And they are responsible to select, evaluate, and if necessary, dismiss the CEO of the hospital. In my speaking notes, there's a long list now of things about the board. It's usually on the order of 10 to 15 members or so. If the board's too small, there's not enough there's not enough people to do what they should be doing, and if the number gets up into the range of 20 or more, it's likely to be too large an organization to function effectively. Most members of the board are local business people. They tend to have money. They tend to be well established. They tend to be near the end of their careers, possibly nearing or even in retirement. They are often asked to be board members because of their knowledge of finance, because that is a critically important aspect of what the board should be overseeing. They may well be on the boards of other organizations. They are likely to serve 2 terms and then rotate out, which is perhaps 5-6 years of active membership. They should not have other relationships with the hospitals, such as being the legal counselor, the external auditor, or other roles that would create serious conflicts of interest. Directors are sometimes paid for their services, but trustees are seldom paid, although both directors and trustees may be paid also for some of the expenses associated with their service to the organization. This is certainly not the place for people to be political partisans, and there certainly should not be evidence of a divide between Democrats and Republicans on the board of a corporation. Directors can be required to own shares of the for-profit hospital, and religious institutions can require that their trustees share the religious affiliation of the institution. The CEO is usually an ex officio member of the board, probably not a voting member of the board. The chief of the medical staff, I'm not sure about this, but I don't know if he or she can be a member of the board, but I think is more likely to be ex officio and non-voting, but I'm not sure about that. I believe it is unusual for hospital employees to be members of the board because that could either be or have the appearance of a conflict of interest. The hospital's legal counsel, in other words, the person who is paid to represent the hospital in legal matters, should not be a member of the board, because to be so would be a likely conflict of interest. Now, it's not likely that you're going to find the kind of people you want to be on the board who do not have some potential possible conflict of interest. When an issue arises about which they have an interest, they should excuse themselves, step out of the room, and not participate in voting on those particular matters. Let me go to the next video now. I'll be back.